started. Good evening, thanks for coming. I am Branse and joined by Rich Roberts. We're with Halloran Sage. We do these seminars from time to time for our client towns. We try to group them together so we're not going down by down. But we want you to know more about the duties that you have and some of the things that arise in the course of doing the land use work that you do. What we'll be presenting tonight will apply to any board or commission that you're on. Wetlands, planning, zoning, ZBA, because it's the stuff that's common to all of those, sort of the procedural things, the things that go wrong. I'm going to be addressing public hearing procedures, and Rich is going to be talking about predetermination and conflict of interest. And like I said, those things apply everywhere. I want to emphasize that the reason we focus on those two topics is that courts are required to defer to your judgment when it comes to credibility of witnesses, or believing which expert, or how to apply your regulations, how to interpret your regulations. So most appeals are lost because of a procedural issue. That's something a judge will not defer to you on. The judge will defer to you on your regulation, criteria, discretion, but they will not defer to you on conflict matters or procedural errors. Every town is trying to save money. One of the ways you save money on legal fees is by avoiding appeals. You avoid appeals by winning appeals and by not making mistakes. I can tell you that some years ago I was involved in a series of hearings about Walmart. They were always controversial. And the commission approved the application. There were two lawyers in opposition. And afterwards I went up to one of them I knew and said, well, are you going to appeal? And he said, Mark, you didn't leave me a crack any thicker than a dime. I've got nothing. I said, thank you. I did my job. So we're going to try to emphasize those things, and the things I'm going to tell you, and Richard can tell you, most things that I'm going to tell you, are what I call the Walmart applications. Your routine things, you may not have to be quite so sticky about this, but when the room is full and people are agitated, then you really need to remember the things that I'm going to be covering here. Quick question with an idea. How many of you are planning and zoning? How many wetlands? How many CBA? One CBA. All right.
He's just a show.
Oh, and how many staff? I forgot to ask that, of course. Okay, there we are. Well, I hope you get a lot out of this. This is being recorded, and I've told Ryan that we'll make it available anyway that they want it. So we'll get started. Is that procedure is important because that's how you avoid successful appeals. Let's see if I get this to work. There you go. All right. Very mentioned, courts don't substitute their judgment for yours. They're mandated not to do that. So it's a matter of discretion. They have to accept what you say. Everything that you do, but I have to keep turning around because it's behind me. Usually I have it on my monitor. This time I really don't. So I can't quite use that. But you have to have substantial evidence for the decisions you make. That term, substantial evidence, those are magic words. Speculation is not evidence. You've all heard this. If they put that subdivision in and an oil truck breaks down, and then the oil truck is hit by a comet and it bursts into flames, and then that's speculation, right? There has to be some reasonable probability that something is going to happen, and not that it might. What if? That's not evidence. And that's especially the case for matters involving expert testimony. And that's wetlands. Wetlands is heavily science-based, as it should be. You have to follow what's called procedural due process. There are two elements to constitutional law from your standpoint: substantive due process and procedural due process. Substantive due process is that your regulations are constitutional. For most of you, that's not going to be a problem. If you're following the state statutes, if you're following normal zoning drafting, that would be like where something was confiscatory, where you're taking away all down of the property, right? Mostly what you're going to run into is procedural due process. And that's, the touchstone there is called fundamental fairness. That the hearing is, regardless of the decision that you make, that you reached that decision in the right way, following the correct procedures. Okay? Pre-application conferences. A lot of towns do them. You're not required to, but you can. It's allowed by statute. It's allowed by case law. And basically what will happen is an applicant will come in and say, we're thinking of filing an application. This is what we have in mind. What do you think? As Rich is going to tell you, what you must avoid in those situations is predetermination. It's one thing to say when you get at one of these pre-app conferences, it's one thing to say, I'm concerned about the number of gas stations in this town, or I'm concerned about the number of fast food outlets. And it's a very different thing to say, I don't care what you say, I'm voting no on this. That's predetermination. All right? So the purpose of a pre-application conference is to identify issues. You don't want to, hopefully, you don't want to ambush the applicant, and they hopefully want to come in prepared. So if there's something you want them to address, you don't need it then. They don't need to answer your questions then. All you're going to say in the pre-application conference is, these are the issues that we foresee. This is the information we're going to want to have. These are the things we want. We're going to want a rendering of that. If this is a very large building or something complex. But don't tell me now what it looks like. That'll happen in the public hearing or when the formal application is filed. But they can be beneficial. They can save time and money for both you and the applicant. And I usually recommend it. Application fees and other incomplete applications. An application once filed is a live bomb. That's why you see the atom bomb up there. Some towns, this is especially important for site plans and subdivision. Why those two? Why those two? Automatic approval. Potential and automatic approval. So when you get a site plan application or a subdivision application, don't just say, oh, it's incomplete, or oh, they didn't pay the fee, I'm sending it back. The clock is running. Your 65-day clock is running. Your site plan, 65 days is automatic approval unless they give you a 65-day extension. Your subdivisions, if you hold a hearing, you don't have to, but if you do, 65 days to open the hearing, 35 days to close it, 65 days to make a decision. If no public hearing, 65 days flat, automatic approval if you miss those timelines. So if the application is incomplete, open the hearing or receive it or whatever you're going to do and deny it as incomplete. Let them start over again. I will take one of our client towns had a constant problem with one or two particular engineering firms. They were constantly bringing in incomplete applications. And then they would say, well, I'll get that to you, I'll get that to you. Meanwhile, your clock is running, all right? And the town engineer is trying to review it, but it's incomplete. And your public works is trying to review it, but it's incomplete. And so what they started doing was the planners ran a checklist. And the night the hearing opened, he would say, this is what's missing. Commission, the applicant would say, oh, I'll get that for you. The chairman would say, no, the hearing closes now. And they denied it. Start over. Message got out eventually. Submit complete applications. And I know that's not nice, but sometimes you have to do things like that. Because otherwise, the information just dribbles in. And by the way, we represent developers also, mostly municipal, but some developers. And I've had this myself, where my clients say to me, just file something. Just get something in, and I'll get the rest in later. And as the attorney, we have to say, no. We are not doing that. But you will still get that. So treat them as, if they're not complete, then they're not. We talked about the procedural due process, substantive due process. You want to compare the application to the regulations. That means the regulations that you have and what they actually say. I can't tell you how many times I've had commissions say, well, we meant to include this, or what we meant to say, or we're about to amend that. I don't care, folks. It's what's on the printed page. That's what it is that you're following. And the words that drive me up the wall. That's how we've always done it, right? Maybe you've always done it wrong. So the regs as they are written. You want to conduct hearings, as I mentioned before, of fundamental fairness. No one feels intimidated. No one wants what's called an atmosphere of hostility. We'll talk about that a little more. Crowd control is essential. And again, these are talking about the controversial hearings. You must set, and this is mostly for chairman and staff, you have to control the crowd. If people start shouting from the back of the room, it gets out of hand very, very fast. I was in a hearing, I won't tell you what town it wasn't anywhere in eastern Connecticut, it was in the west. It was a gravel pit application. And the neighbors were circulating a petition against it. They were circulating it through the room. But one of the proponents, when the petition came past him, he grabbed it, put it in his pocket. Well, people saw him do it. So they said, take that back. And so there was a little scuffle. They had a state trooper there. Smart. State trooper tried to intervene. The crowd pinned him against the wall. All right? They had to adjourn the hearing and reconvene with 3 state troopers. If you need a police officer there, have one there. Once people start shouting or heckling, discourage applause, obviously discourage booing. It is not a popularity contest. I always try to explain to people, if we took a vote in your town, and every voter agreed that we're going to take your house and not pay you for it, could we do it? No. People have property rights. Developers have property rights. And they need to be able to apply under your regulations and not be booed or heckled or intimidated. So you really want to watch that. You want to watch jokes, too. They don't transcribe well, folks. There's a famous case, the Pirozello case. Mr. Pirozello was filing an application, and somehow the topic of his garden came up. I forget how. And the applicant's expert, cracked a joke about Mr. Pirozello and how Italians love their gardens. And a commissioner joked back. On appeal, the court held that he may have been joking, but an atmosphere was created of hostility toward people of Italian descent. No jokes, no sarcasm, keep it straight. Not only do you ever run the risk of a successful appeal, but you also run the risk of a civil rights action. When people say things that they should not say, any comments about religion, race, ethnicity, national origin, any of those, that is never appropriate, it is never funny. You just have to really watch that. Comments should be directed to the commission. You will always, by the way, I love Zoom meetings. I love virtual meetings because you don't get that applause, the booing and stuff like that. People say what they have to say and then they click off. But in a live meeting, somebody is going to come up to the commission and turn and say, do we want this, folks? How do we know? You cannot have that. All right, again, it's not a popularity contest. It is not majority rules. You want people to speak only one at a time. Again, this is mostly your chairman. That includes commission members. I was in a hearing Tuesday night where the chairman allowed multiple commission members to interrupt each other, talk at one time, fire questions at the applicant, to get multiple questions from different people at the same time. First of all, you'll never get a transcript of that. But second of all, it just creates chaos. Right? You've got to have an orderly procedure. You want a certain level of formality. Judges get that feeling when they hear the chairman address the applicant and say, well, Jim Bob, or the applicant says to the chairman, hi, Billy, I attend your hearings, I've known these people for decades. But when I'm in this room, it's Mr. Bray, Madam Chairman, whatever. No first names. This is a legal proceeding, and you want to send a message to the people in attendance that this is a formal proceeding, that this is not a party. By the way, if you have questions, feel free to just raise your hand. There's you and others, we can do that. Let's see what we got here. Yeah, never allow anyone to interrupt a commission member. Once that starts, again, it spins out of control very, very fast. Some of you, I don't know, probably not, but depending on who's here, some of you may watch me do this. I will just say, when someone does that, I'll say, never interrupt a commission member. chairman will tell you when it's your turn to speak. Because again, once it starts, it really deteriorates very, very fast. Try to keep people, yes?
If the chairman does not speak up right away to say stop this, can any of the other commission members speak up to say stop this, it's
Yes.
not allowed?
Staff, another commission member,
Okay.
yes. Because like I say, it gets out of control. I was at a hearing some years ago involving an Islamic cemetery, right? And the only thing missing were the torches and the white sheets. I mean, this crowd was a hostile crowd, right? And they were catcalling, and I had to say, the next person who speaks up, we had a state trooper there. The next person who speaks out will be removed from the room. Do not test me. I will do it. And it stopped it. But otherwise, it would have spun totally out of control. Yes.
Sure. I'm glad that lady brought that up because I've had that incident. My question to you would be, could being the chair, could say I appoint a sergeant at arms?
Sure, but not.
Well, I mean to control
But not a
that.
commission member.
Excuse me?
But not a commission member.
That was my question. So if somebody wants to do it for us that night, if we don't have a trooper or a constable or something.
If you're expecting trouble, have the constable.
Yeah,
If you possibly can, because the uniform makes a big difference. Right? People hopefully are less willing.
Yeah. If a chair is slow to act and a member wants to bring it up, should they address the chair to bring the issue up rather than address whoever in the audience? Just to keep that order?
Sure. It's better. Madam Chairman, I think we need to keep this one person at a time. I hear people trying to interrupt. Could you try to? I think we can control that. Sure. I mean, some chairmen are really good at that. You are. And some, are shy. And you're volunteers. I have to say that I think a lot of this falls on staff because you have to be elected. You have to live in the town. Right? A lot of times, mostly staff, don't live in the town. And I always tell people in our client towns, I'm not running for election. I don't live here. I don't care how mad they get at me. They can be mad. I can be the big bad lawyer from Hartford. I don't mind. All right? I'll be the nasty one who says there'll be no further interruptions. And that's why I did in that particular hearing, because I didn't want to put the chair. I didn't want that there was like 100 people there. This was the high school auditorium. I did not want the chairman to have to do that. She wasn't. They don't pay her enough for that. I know you guys get time and a half after 10 o'clock, by the way. Don't run too late at night. I promise you, the later it gets, the more likely it is that something is going to go wrong. Somebody's going to say something that doesn't look good in the transcript. Tempers are going to get raw. I returned from the hearing this week. Got home at 1:45 in the morning. My wife always says to me, she says, how can you be making good decisions at this hour? My response is, who says they're making good decisions at this hour? Better to end at 10 o'clock or whatever and have a special meeting the following week. Better have a couple meetings and go till midnight or 1 a.m. when tempers get raw. We're not trying to create business for ourselves. If you expect trouble, have your attorney there. We can do so much more for you at the hearing. Once the mistake is made, we can't fix it, right? Once the hearing closes and there's an error, I will give a quick example. I had a situation where I was at the commission meeting. It was late. Tempers were getting raw, and the commissioner said, you don't get it. I don't like that building. And this was a pre-application comments. And I said, I think, Commissioner, what you mean is that the applicant is free to proceed, but that the road to approval could be rather steep and long. Wasn't that your point? Yes, that's what I meant. Okay? We can fix things here. We can't fix them after.
Sure. Yes. Just what you just said. Set the meeting to 10 o'clock. I like that idea because we had been having quite a few events going a little bit beyond it. But if at the same time, when calling the meeting at 10 o'clock to end it, can bring it up, say, we're going to have this special meeting following Monday or Wednesday, which is I have to find out availability, but don't want it to go too long too, correct?
If I'm talking for an advertised public hearing, right, if you need to continue for any reason, you want to announce before that hearing closes, the time, the place, and the date of the continuation, because if you do, you don't have to re-advertise it. So I mentioned a minute ago about continuing to the following week. Well, you don't have time to advertise in 1 week. Your first notice has to be at least 10 days prior. But if you announce it that night, if you don't know the room, don't say, we'll announce the room later. No, it will be in this room. If this room, whatever it is, isn't available, you have to sign the door. The continued P&Z hearing is in conference room A, or wherever it happens to be. All right. That's it. You want to set up the rules in advance. Tell people, what this is about, so they understand. One of the things that one of the planners well, she's retired now, she would do is when people arrived, she had the pages from the zoning regulation that had the criteria for that type of regulation of application, whether it was a special permit or a site plan or whatever it was, and she would say, this is what the commission is going to be looking at. So, and it really worked very well in a number of cases where people would read that over and jog something in their memory or something, and they would address that specific criteria. And that's the best thing that can happen in a hearing. So explain to people what kind of application is it a subdivision? Is it a site plan? What is it? Tell them what the sequence is going to be. We're going to hear from the applicant first. Why? We indulge this quaint notion that people want to hear what the application is before they tell you why they're against it. It's a nice theory anyway. So we hear from the applicant, questions from commission and staff, then proponents, then opponents. Now sometimes you do this differently, and you can do it any way you want to. I was at one hearing where they heard from one proponent, and then one opponent, and until they ran out of one of them, and then that's okay. Or it can say proponents, opponents, people who are neither. As long as you give a chance for everybody to hear it, we should be okay. You want to tell people right off the bat, no shouting, no applause, no interruptions. We won't accept that. We will eject people who can't follow these rules and do it. What else we got? You want to keep people in line, including the applicant. I know of a particular attorney who actually tries to incite the crowd. He wants to inflame the crowd so that they'll say things that are prejudicial, and then on appeal he can say there was a hostile environment. People were saying these terrible things. Now you kind of asked for it, but what he did, he wanted people to say those things. You want to avoid that as well. Keep your commission members in line as well, that they don't interrupt, be hostile, be rude. And that's always tricky. I said having the police up, and the other thing I'll say to you is always have a room that's more than big enough. What happens when the room is packed is there's this anonymity. People, and someone in the back will shout something out because you can't really see them, all right? So you want there to be plenty of space. You always want to have a public address system, again, for a large crowd. I promise you, someone will sit in the back row and say, I can't hear, or I can't see. Yeah, well, then move to the front, right? But they won't do that, all right? They really just want to disrupt the proceedings, is what those people are doing. If you need to have a way to display things, a screen, an easel, something, all right? I have been in many hearings where there's one easel, and if they face it toward the commission, the crowd can't see it. If they face it to the crowd, the commission can't see it. So they try to put it halfway where nobody can see it. Have a way to show things. We talked about the applicants, how that works. I don't know what that looks like on the screen yet. If there's no public hearing, let's say it's a site plan, or something doesn't require a public hearing and you're going to hold one, the chairman can allow the public to speak. if they wish, but you don't have to. And you can cut it off anytime you want to. It's a little different with wetlands, as I think all of you know. Wetlands is the only statute that says, thou shalt not hold a public hearing unless, Amendment 3, a petition of 25 or more people within 14 days of date of receipt, if it's a significant activity or if it's, quote, in the public interest, whatever that means. In that case, you do want to be a little more careful that it doesn't turn into a public hearing. But even there, I know the DEP gave some advice. Don't let anyone speak if it's not a public hearing. I think that's a little too strict. I think you can let one or two people talk. But if you begin to get, if there is a crowd of people, then just say it's in the public interest to hold. Stop. It's in the public interest to hold a public hearing. Schedule a public hearing. Proceed. One other thing for wetlands, while I'm on that, just so we don't use this, one of the things I often see too with wetlands commissions is you receive an application. And you'll say, well, should we hold a public hearing on it? Yes or no, but yes. Why? Are you holding a public hearing because you think it's a significant activity? If so, it triggers the no feasible improvement alternative test. If it's just in the public interest or you get a petition, it does not trigger the no feasible improvement alternative test. So, you want to decide at the earliest possible stage if we're going to have a public hearing and why. If you're doing it because it's a significant activity, you need to say so. And by the way, folks, wetlands commissioners, if there is the slightest chance that a wetlands application is going to be denied, it's a significant activity. There is nothing worse for us attorneys than have to defend a denial for an activity that you said wasn't even significant. If it wasn't significant, why did you deny it? Right? So if there's anything in there that looks like it might be a denial, then it's a significant activity. Hold a public hearing on that basis.
Mark?
Yeah.
So when you say that people allow people to speak if it's not a public hearing,
At your discretion.
What's the chairman's limitations on that?
Really, the chairman has discretion.
So you questioning or comment or so?
I mean,
Because that can get out of hand.
it's small. Well, exactly. It can get out of hand. So it is a matter of judgment. You know, like I say, if you've got one person or two people who want to say something, you know, fine. If you have a room full of people, that tells you that it's time for a public hearing. You know, if you've got the wetlands or whatever it is, then you want to have a public hearing. So you have a record, so it's recorded, so you go through all these procedural requirements. Cross-examination can be permitted, but few rules. One, you don't cross-examine commission members. They're not testifying, at least they better not be. Commission members don't testify. They listen, they ask questions, they deliberate, they vote. But it is permissible for someone to demand the right to cross-examine a witness. I will tell you this much. If that happens, it will almost certainly be a lawyer. It doesn't have to be, but it will be. It will be a lawyer. And the lawyer is hoping that you'll say no, because then they have a successful appeal. They have the right to cross-examine witnesses. Right? So what you want to do, this is for chairman, if you get someone, and we're not there, if you get someone who wants a Perry Mason style cross-examination, you can say to the attorney, or whoever it is, you know, we're a small town, we try to keep things kind of informal around here. Would you mind asking your questions to the chair, and we'll get you the answers? Now, as this person has a choice, they can say, yes, I'm willing to do it that way, in which case they've waived a claim on appeal. If they say, no, I demand the right to cross-examine a witness, Perry Mason style, then you know they're trying to trap you, and let them do it. No one has ever gotten anything worthwhile out of cross-examining a witness in his own year. So let them go ahead and have fun. All they're trying to do is trick you. Really, at 99% of the time. Otherwise, they would just ask the question and get an answer. Right? The fact that they're demanding cross-examination means they're setting you up, in my experience. Sidewalks. These are especially important for wetlands. And the reason I say that is, in most of your zoning and ZBA situations, you can see what you need to see from the road or from some public place. Wetlands, you're often bushwhacking, you know, through the woods, right? If it is a site walk in connection with your review, you must advertise it as a meeting. It must be open to the public. Some applicants will say to you, I'll let the commission go, but I'm not going to let those rabble from the neighborhood. The answer is that nobody's going. If a lawyer says to you, the lawyer, well, we'll let the commissioner and staff go on the property, but we can't let the public go on because of liability. If they say that, lawyers have a term for that. It's called lying, right? The property is either insured or it's not. If it's not insured, nobody goes on it. If it's insured, anybody can go on it. Somebody breaks into your house, burglar breaks into your house and slips on your kid's skateboard, they can sue you and they can win. They'll go to jail, of course, right? But liability is everywhere. That's why people carry insurance, right? Stay together. I was at one site walk where we arrived at the site and the commission members just scattered. And when the meeting reconvened back at Town Hall, some people had seen one thing, some had seen the other thing, and who knows what the public saw. Everyone is supposed to see the same things. You're all supposed to be working from the same base of information. Rich is going to talk to you about ex-parte communication, which is when people receive information. Some commissioners receive information that the others didn't get, and that is not in compliance with fundamental fairness, that touchstone of procedural due process. No comments during the site walk because you'll never get a decent recording. Right, so assuming the hearing's open, questions about orientation. The engineer says that line of blue flags, that's the wetlands, those yellow flags are the future road. Those kinds of things are okay to say during a site walk, but you don't want testimony. That stuff happens back when the recorder is running back in your meeting room. And if a commissioner is unable to go on a site walk, then you have a staff person take that person to the property and show them the same things that all the other commissioners saw. I was part of an application in Old Saybrook. It was a 1,000-acre piece of property. And they had a site walk, and they visited specific parts of this property. One commissioner missed it. He wanted to go back with the planner. The planner started taking on that route. He said, well, I want to go over there. And the planner said, no. The site walk, we didn't go there. And so you're not going there. I'm only taking you where everyone else went. So you all saw the same things. Testimony, people in, yes?
We had a site walk, and instead of doing it as a commission, the applicant said, you know, whenever anybody individual is ready to go, I'll be here and take you and show you. So the members went one at a time.
And was that property you couldn't see from the road?
Yes.
From a public place?
Well, you could see the road frontage from the road,
but not what you needed to see.
Right.
The Freedom of Information Commission has ruled on that specific situation, and they have said it is a violation of the Freedom of Information Act. Do not do that. Do not do that. Right? Again, you're depriving the public. When you do that, you've seen things that the public can't see. They're being deprived of the basic information that you will use and properly use to make your decision. Yes?
This wasn't a public hearing. This was just the application came before us.
It was wetlands, you said?
Yes.
It's still not, it is not a good practice because, again, you're seeing things that other people can't see. Right? You should go together. Let's see. Commissioners should not testify. If a commissioner has special expertise, and many of you are blessed to have people who have that expertise, if they're going to rely on that, they should disclose it. We've represented Willington for many, many years. The planner there had what I thought was a great idea. Because Willington is so close to Yukon, they always had some really high-powered people on their commissions. At one point on their wetlands commission, they had the state's top botanist, and they had a PhD entomologist. I mean, they had these really high-powered people. And so what the planner did there was she got the resumes for these people, and every file she opened, she just put the resume into the file. Now it's on the record that these people don't have to say, I'm a professor of pneumology at UConn, or you don't want to do that every single time, right? So she put that in the file, and that way it was in the record. And an applicant or public is supposed to know what's in the file, right? So that way you disclose that expertise. Let's see. Your job is to listen and see what and compare to the regulations and not to testify in jail. The man can be treated with respect. Again, people interrupting, shouting, those kinds of things, they get around very, very fast. Treat your own staff with respect. You should do that always, of course, but especially in a public setting. Your staff is there to make your life easier, and when the public sees your staff being belittled, it's not the image that you want. I was at a hearing, by the way, nowhere near here, nowhere in Eaton's part of Connecticut, where throughout the course of a very controversial hearing, the commission just berated their planner at length, and for no good reason, I would add. And I mean, it was horrible to watch. And it just made the whole commission, it made everybody look bad. It just undermined confidence in the whole process. I already said refer to each other with formality, Commissioner so-and-so, Mr. so-and-so. Yes?
Can you talk about, like, members of other commissions attending meetings and how their decorum should be?
You mean like a wetlands commissioner going to a planning and zoning commission meeting, that kind of thing? Yeah?
Vice versa.
And
Or vice versa, whatever. Well, sure. I mean, a member of a commission ought to know what being a volunteer on a commission involves. The hours and the thankless nature of it, for God's sake, okay? So certainly when you attend some other commission meeting, you want to treat them the way that you would like to be treated if they were at your meeting. And of course, Rich is going to address this, and of course you never appear in a representative capacity. He'll get into that though. Reports, exhibits. It's a good idea to mark exhibits like you do in a courtroom again. It's a complicated application, not your simple routine thing. One of the things, if any of you want to go to the old Saybrook website, I was mentioned before with that 1,000-acre development. As a favor to me, they have left the record up on their website, even though the application was resolved years ago. And they do that so that you can go look at it. And what Old Saybrook did in that case, and there were hundreds of exhibits. And what they did is, as soon as they got a document, they stamped it with an exhibit number, scanned it, and put it on the website. So, first of all, it kept everything very orderly as to what they received. The other great thing about that was that, people dribble in to the office. I want a copy of this, or I want a copy of that. You make a copy, and an hour later, somebody else comes in and wants a copy of the same document. This takes a lot of staff time, especially when it's a controversial application. In Old Saybrook, they're able to say, it's on the website, you can download it, you can enlarge it, you can print it, there's menus and whatever you want. And it made it so much easier for them. So that is a blue practice. You want to have that, I don't know what that is. I thought it just from off. Okay, everything up. All right, thanks for that. You want to have adequate time to review things. I know sometimes that doesn't happen. Or sometimes at the last minute of the hearing, you get a document, you don't have time to review it. We'll have to cover that. That's something we try to avoid, honestly. For electronic presentations, if someone brings in a video or something, ask them that they need to put it in the record. They need to put that video. They can't just show it you and then take it away, because then you don't have it on the record anymore. Staff input, you are allowed to accept staff input after the close of a public hearing, but only to comment on information that's received during the hearing. Even staff, after the close of the hearing, cannot raise new issues or bring in new information. Some years ago, I was involved in the town in an application for a dog kennel. And the applicant had presented a noise study, an acoustic engineering study. And after the hearing closed, which was a mistake by itself, the commission said, well, we want an acoustic engineer to review that and advise us. So I contacted an acoustic engineer who I knew and told him what I needed. And he said, Mark, great time. Our institute just published a comprehensive study on dog kennels. So I could give you that. And I said, no, you can't. That's new information. All you can do is review the applicant's acoustic engineer and tell us whether it followed the proper procedure that acoustic engineers use. Is the methodology and the conclusion supported by the evidence? That is all that you can do. No new information. Yes?
On staff report, when you have the public hearing and staff is the person who has reviewed the application and some of the comments or some of the points that the staff has picked up that's not brought out in the public hearing, can the staff ask, say, I would like to speak and make sure that we have X, Y, and Z clear before we close the public hearing? Can the staff?
I'm sure I'm following you. The staff feels that some comments have not been addressed before the
Right, it's something the staff has picked up and has not been addressed. Can we state that to the commission
Yes.
and to the public during the public hearing?
Absolutely, because the hearing is still open. So the applicant could say, they say, oh my gosh, I meant to address that, but now I forgot. All right, we're all human. Or maybe something the applicant didn't want to address. Either way, yes, as long as the hearing is open, definitely yes.
Okay, because you can't bring it up when the hearing is closed.
You are not bound by staff input, you commissioners. Frequently,
What was that again, bound what?
you are not bound by staff advice. It's advice. So you'll often hear someone say, well, the town engineer thought that this was reasonable. Well, that's his advice, but unless we're talking in matters of expert opinion, which I'm not going to get into too deeply here, but basically the fact that the staff thinks something's okay, if it's a matter of discretion, that doesn't mean you have to find that it's okay. That's kind of very specific. Note one thing, ZBA members. Normally, I told you before, staff can speak after the close of the public hearing. But if the ZBA is hearing an appeal of the ZEO's decision, then the ZEO is an interested party. And in that case, the ZEO cannot speak after the close of the public hearing. ZBAs are accustomed to having their staff talk to them after the hearing closes, like on variances. So ZEOs, you need to say to the board, look, normally I can talk to you after the hearing closes, but because my decision is being appealed, in this case you can't. So if there's something you want to ask me, you have to ask me now. Once the hearing closes, I will not be able to comment any further. There was one case, it was a ZBA appeal of the ZEO decision, and at the night of the deliberations, the commission's clerk was absent. So the ZEO, whose decision was being appealed, did the minutes. On appeal, the applicant's attorney argued that the ZEO must have influenced the board because the minutes that he took reflected what the commission actually said. Now, aren't minutes always supposed to reflect what the board really said? That did not move. Good idea, I said to number evidence, to give them number. This is also good, like again, the controversial hearing, and you can help them. The engineer stands up there and says, on this drawing here, Mr. Smith, you're referring to Exhibit A, the sheet 1 of the sets. Yes, okay. Because when a judge reads a transcript, it means nothing for a judge to see. On this sheet here it shows, but on this sheet over here it shows. The judge has no idea what you're talking about. So you try to prompt people what it is they're, even if it doesn't have an exhibit number. So you're looking at the subdivision set, Mr. Smith. Yes, I have that on the board. Subdivision set, and I'm looking at sheet number 2 or whatever. Expert input. You'll hear about this a lot. You will hear people say to you that you must believe the testimony of an expert. That is not quite true. Well, it's not true at all. What is true is you must believe the testimony, the uncontradicted testimony of an expert on a matter that requires expertise and where you lack that expertise yourself. A couple of examples. Wetlands hearing, the applicant had his own biologist, his own wetlands biologist, And the commission members asked repeatedly, well, this activity could this cause nutrient loading in the wetland? And the expert said, well, yes, it could create wetlands, nutrient loading wetlands, but in my opinion, not to a significant level. Well, is it true that you might have these? And they kept asking about it, and he said, well, yes, those impacts are foreseeable, but in my opinion, they're not significant. Commission denied the application. On appeal, the attorney said it was uncontradicted expert testimony that these impacts were not significant. And the judge said that was not his call. The expert admitted that the nutrient loading and the erosion, and he admitted that all these things would happen. It was not his call to determine whether they were acceptable levels. That was the commission's job, right? Another thing you'll get in this a lot of times is traffic. Traffic engineers, if a traffic engineer tells you that this is the trip generation, the ITE trip generation, you can't say, I don't believe that, it's more than that. That's a matter of expertise. But if the traffic engineer says, this happened, by the way, in one of our coastal towns. I took my counts in January, coastal town. So I plugged in the standard factor for summer. And the commissioners literally laughed. They said, you're not here in the summertime, man. You know, you're allowed to use your local knowledge of existing conditions, right? And the other piece of this is, you must believe the uncontradicted testimony of an expert on a matter that requires expertise. Where you don't explain to the expert why you don't believe them and give them the opportunity to restore their credibility. I served a 7-year sentence on the Planning and Zoning Commission in my own town, and we had a traffic engineer come in, and he testified that this particular thing would have no adverse impacts, of course. And I said to him, are you aware that just around the corner from this property, a 5-story hotel was approved? He said, no, I didn't know that. So are you aware that one of your driveways has already been approved to serve a 65,000 square foot shopping center? He said, no, I didn't know that. I said, are you aware that around to the southwest, a 3-story office building was just approved? No, I didn't know that. I said, I want to state for the record, I find your testimony not credible because you have not evaluated future development that's approved already that we know about, and you apparently did not. I can do that. I told him why I didn't believe it, and I gave him the opportunity to explain why this. If I'd done that at the hearing closed, that would be improper because he can't respond anymore. Right? You record everything, of course. You want to record who is speaking. Be clear. One of the things I see, actually saw it in this room, speak up. Okay? I don't want somebody sitting there going, okay, you know. Not only does the tape not pick it up, the public can hear you either. So it's a public proceeding. You know, don't be shy. If you need a microphone, get a microphone. I think something. And other people are allowed to tape your meeting, but they cannot disrupt your meeting. So if they want to set up a videotape or recording machine, that's fine. But they don't get to weave in and out among you, you know, with their little tape machine. As I say, you may rely on your own knowledge of general things that which anyone in the community would know. You're allowed to use your knowledge of when traffic is heaviest in your town, or when the river floods, or those kinds of things. Those aren't matters of expertise. They're things that anybody would know. Talk about cross-examination. If you do testify, you can be cross-examined, so be careful. Once the hearing closes, then no new information. You don't, after the hearing closes, you don't say, well, I was on the internet and I saw. No, hearing's closed. There was one case, there was a site walk, and the issue, there was a subdivision, and the issue in the subdivision was that there was an abandoned well. That was undisputed. And the neighbors were saying that this subdivision would cause contaminants to go into that well and into the groundwater and contaminate their wells. There was a site walk. One of the commissioners saw a pipe in the ground. She didn't say anything about it. Hearing continued. She didn't say anything about it. Hearing closed. In deliberation, she says, well, I saw that abandoned well. I saw that white plastic pipe. And I know that was the well, and yeah, where it's based on its location, it could cause contamination. That wasn't the abandoned well. That was a tested bed. All right, but the hearing was closed. Nobody could correct her. It was appealed, and the judge overturned the decision. You know, she had to say in time for somebody to correct her that she saw something that she was going to rely on. I know I'm repeating myself. Fundamental fairness. Ask yourself, would this be fair? If you were the applicant, would you consider this a fair proceeding if something like that happened? Let's see. You have to make the decision based on the regulations. We talked about that. You can no longer waive your zoning regulations. That's the McKenzie case. You do have the right to interpret your regulations if there's an ambiguity, but then interpret them consistently. The court is never bound by the way you interpret your regulations, but they will consider it. And especially if that interpretation is time-tested. That's a quote right from the case called Newman versus Avon Planning and Zoning Commission, where the planner said, we have consistently applied this regulation in this way. And the court said, well, I'm going to accept that. I don't have to, but I will. It was a reasonable interpretation. You can't twist it to say something it doesn't say. But that was a case where the regulation had room for interpretation, and the judge deferred to that. Things you want to ask yourself when you're considering an application: what evidence did I hear about this criteria? What do I conclude from that evidence? And were the criteria met? Some years ago, I had a very difficult appeal in one of my towns. The commission made a decision that was challengeable, put it that way. They took 3 nights of deliberations. They went through the regulation line by line, and for each one they said, what evidence do we hear on this criteria? And they talked about it. And when it got to appeal, I said to the judge, Your Honor, I challenge you to read the transcript of those 3 nights of deliberations and tell me that this commission was arbitrary and capricious. That's the wording, and abused their discretion in the upheld decision. Because he agreed that they had been very thorough and really weighed the evidence, even though it was a decision that you can understand could be challenged, right? Always have some discussion, again, on a controversial application. Judges hate it when you listen to 12 hours of testimony. And somebody says, I move approval, second, all those in favor, aye. It doesn't look like it, all right? If you've heard that much testimony, there ought to be a little bit that you want to talk about. Some things you want to say as to what influenced you, what didn't. Denial of prejudice. I had a judge tell me there is no such thing, but I think there is. Denial of prejudice means we were unable to reach the merits. The legal notice was defective, or the application was incomplete, or something like that you weren't able to determine whether the application was compliant or not. And yet you can't approve it, again, because of some flaw, some procedural flaw. I think that sends a message that you have not reached a conclusion that it's a good application or a bad one. You're deferring that whole issue. Reconsideration. The general rule is that once the legal notice is published, you cannot reconsider. Prior to publication of the legal notice, you can reconsider only with, and I quote, a good reason, said the judge. I don't know what that is. But generally speaking, don't reconsider. This is a place where Robert's Rules of Order is not appropriate for a land use commission. Robert's Rules of Order says you can reconsider. You can't. You want to publish notes first. Time limits. I'm not getting into too much. I will talk about the motion. Again, if it's a complicated application, take your time on the motion. Work with staff. Have your staff work with your town attorney. All use us. In that old Sabre case I've talked about several times, the motion was about 50 pages of findings and conditions and modifications, because we knew that was going to appeal, and it did, we prevailed. So take your time in the motion. One of the things that I don't know if they still do it, but they used to do it in Mansfield. They never voted the night, unless it was routine. They never voted the night that the hearing closed. They would have 1 or 2 commission members be a subcommittee with the town planner, and they would work on the motion. It would be sent to the commissioners in advance. So you have a written motion at the end of the day. Be specific with conditions or modifications. This drives us crazy. Speaking of a big issue in one of our towns, the ZBA granted a variance on the condition, it was a B&B. They allowed the B&B to host events. The variance said to host teas and other intimate events. What's that? They started hosting weddings for 100 people. And the CEO said, I don't think that's what they meant. Issued a cease and desist order. It was appealed to that same ZBA. The ZBA said, oh yeah, that's what we meant. 100 people is an intimate tea. I got it. No, okay. They should have said, and you got to be specific about this stuff. There's a bunch of other cases. One of them was Dodson Bogart, which was a variance case, where they gave a variance to the tiny addition of the building, and then Dodson said, well, that meant the whole side yard was waived, the whole length of this building was 200 feet long. Right? So be clear on what you're approving. The defeat of a motion to deny is not a decision. You haven't voted yet. The defeat of a motion to approve is a decision. Stop. Okay? If the motion to deny to grant isn't carried, you're done. You have denied the application. This is why many lawyers will tell you to always phrase an application, a motion in the affirmative. Even if you don't think it's going to carry, I move that we approve application, blah, blah, blah. Because then if the motion fails, you're done. Be prepared. Read your regulation, obviously. Review the material. I was at a commission meeting at one point where I referenced a section of zoning regulations, and not one member of the commission had their zoning regulations with them. That is inexcusable. That should never happen. View the property if you need to. Fine. If the regs don't say what you want them to say, change that. All right. And again, we're not looking for business. I particularly am not.
I'm going to back you up a little bit because it came to me after you were moving on.
Right.
Well, everything you just said, well taken on what I went through. But it has to go back to setting a time limit like 10 o'clock and then pushing, saying that before you end that meeting at night, before you close the meeting, you say, okay, we want to take it to a special meeting. Sometimes the following week, we might not be able to use the same room.
You put a sign up.
Excuse me?
Put up a sign.
Yeah.
Easy meeting scheduled for this room is in this other room.
Or can we take it to another building?
As long as you have a sign. For example,
Well, that's what I'm trying to say.
yes,
We have
put up
another
a
building.
wherever,
We have to use it.
I'll tell you when this will come up. You advertise for the room, and it turns out that it's such a controversial application, the room is too small. Right?
Correct.
So you're going to adjourn to the high school auditorium. Right? You put up a sign. Hearing scheduled for tonight of the Planning and Zoning Commission of Town X is now at the high school auditorium, and give the address, even though everybody knows where the high school is. Give the address, and allow a little extra time for people to go to the first room, figure out they're in the wrong place, get to the right place. So one other thing I should address, time limits on speaking. There's case law right on this, so we have an answer. You can set a time limit on people speaking at a public hearing, 3 minutes or whatever, but only for their first time at bat. After that, you have to let them come back, and again, as long as it's relevant, as long as it's respectful and so on, you have to give them more time. If you cap someone at an absolute top time, no matter who they are or what they're saying, no matter how relevant it is, you're probably going to be overturned on appeal.
I'm misunderstanding. So they say, I'd like to speak, I get 3 minutes.
Yep.
Okay, so
Everybody gets their
then
first
you're
3
saying
minutes.
other people talk, and then I want to speak again, then I can go beyond the 3 minutes.
As long as everyone has the chance
Okay.
to say what they have to say. Again, as long as it's relevant.
All right, so I don't have to keep jumping up for another 3 minutes.
No.
Okay.
Yeah. Yes. As long as everyone has, the idea here would be we want to hear from everybody
Yeah, but you're not an
tonight.
introductory to make sure everyone gets their.
Everyone gets their chance tonight, right? And then when everybody's had their first 3 minutes, then we'll go
Okay.
back and we'll
All right.
supplement what you have to say. Yes.
If it is site plan, can there be I know you said we don't even have to let the public speak during the site plan. But say if they want to adjourn, can they say we'll accept comments for 15 minutes or 20 minutes? Total
As not a public hearing, so it's really at the courtesy of the There's another one, yes.
My question is specific to the actual vote. Do you have suggestions for boards regarding audible votes versus hand raised? Like, what's the structure that's generally recommended? Because sometimes it's not very clear to hear.
It really, under the FOI, you have to state who voted how. So if there's any expectation there will be a divided vote, then do a roll call vote. Mr. Smith, Mr. Jones, aye, nay, blah, 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 okay. Much of your routine stuff, it's going to be unanimous. So if you're voting on something you already know it's going to be approved, all those in favor, aye. All right, let the minutes indicate it was a unanimous vote. When it's a unanimous vote, you don't need to say, obviously you need to designate who's the voting alternate. Right, that you do at the beginning, and I didn't get into that, I can if you want to.
And if it's a hybrid meeting with a divided vote, you have to do a roll call.
Right, right, because we don't know, the people online may not be visible to the public. I don't know that. Brian? Where'd you go?
In the back.
Oh, yeah, can you load up Rich's outline? There'll be some more questions, we'll take a couple minutes. Anything else on that? By the way, I do the same thing for the kinetic zoning enforcement officers. You take 2 days before. I'm not going to be here for 2 days. Yep.
You made a comment about subcommittees, and something I kind of thought about in terms of, maybe the expertise does not exist on the board, right? And you may need to rely on other expertise, right? So I'd like to learn a little bit more about that subcommittee aspect of it. Is it completely different than, is there some options there where you could call, a subcommittee to be able to pull these subject matter experts in?
The issue of experts and subcommittees are don't conflict those two.
Got it.
You can always designate a subcommittee to work on your plan development or zoning regular amendments or whatever it may be.
Yep.
But that subcommittee is an agency. It has to post agendas, it has to be open to public, it has to have minutes, all those normal things. As far as use of experts, whether your commission wants to retain outside experts, that is something you as a commission can discuss, can vote on. And remember, under 8.1c of the statutes, you can have an ordinance, in most cases a regulation as well, that allows the applicant to reimburse you or even prepay for the expertise that you need. It is authorized by statute. So there's no reason why your taxpayer should be paying for that. That should be paid by the applicant. I'll tell you, I represented an applicant on a really big project, and our reimbursements for the town's experts were over $450,000. And when we got the approval, my client said it was the best money that he spent on the process. Because it was a big project, the commission was scared, justifiably scared, and so we had a traffic engineer, they had a traffic engineer. We had a landscape architect, they had a landscape architect. And each of their experts said, yes, this is valid, this is correct, and it gave the commission a comfort level to approve this really big project that they probably would have been afraid to do if they didn't have experts matching our experts.
Oh, thank you. That's what I was looking for.
All right, turn it over to Rich. Conflict of interest, predetermination.
Do we have about 5 minutes to get up and stretch?
Yeah, sure thing.
Everybody will be more
I'll come
comfortable.
back at 17.
Put your timer on.
8. That clock is wrong.
Can't hear. Where's the microphone?
As with Mark's presentation, this is part of what we did during the Yukon Clear Land Use Academy program. And each of our presentations there are 90 minutes long. Kind of on the fast track here, one of the things that is missing and have been cut out is a lot of the kind of quiz clicker slides that are in those programs that aren't in here, so it should expedite it a little bit. But the subjects that are included in this material are conflicts of interest, real ones as well as perceived ones, predisposition and bias, and recusal. One of the things that Mark alluded to when the question came up of, members of boards and commissions appearing before other agencies. One thing that's black and white in the statute is that if you're a member of the P&Z or the ZBA, you can't appear on behalf of someone else before either your own commission or the other one. So, if you're a planning and zoning commission member, you can't show up at the ZBA representing someone else. You can represent your own interests before your own commission or somebody else's, but you can't represent someone else. The theory is that it just doesn't look good. And there are different statutes that apply to both planning and zoning, ZBA, wetlands, and other land use agencies that essentially say the same thing. One of the other statutory conflict of interest provisions is that if you're on planning and zoning or ZBA, you can't participate in a hearing or deliberation on any matter in which you have either a personal or a financial interest, direct or indirect. And that's a lot to unpack, but, it's basically black and white law. So when is it appropriate to represent your own interests? When you're the applicant, when you're, an abutter to an application that's going to have impacts on your property, or when you're otherwise personally, affected by or have an opinion on an application. But bear in mind that if you do appear before either your agency or the other ones, you can't participate in the decision or the deliberations. You have to recuse yourself. One of the other things that kind of flows from that is that when you've decided to recuse yourself, you should probably not come back up and sit with the commission after you've just testified heatedly about something that they're still going to be deliberating on. Ideally, you'll either sit in the back of the room and be quiet, or you'll leave. The last thing you want to do is be sitting in the audience clapping and cheering and shaking your head and rolling your eyes and things like that while your own commission is making decisions on either your own application or one that you have a strong interest in. It's not a good look. If you've recused yourself, make sure that it's noted in the record that you've disqualified yourself, that you're replaced by an alternate. There is a statute that creates a process by which members of the public, electors generally can be kind of rounded up like a posse to be alternates if so many people have had to recuse themselves, that you don't have the ability to have a full board or commission. I've never seen that happen. I've never even heard of that happening, but I guess, if you live in a town that's small enough where everybody works for the same company or something like that, and they're the applicant for an expansion, and everybody would have a conflict in order to make sure that their application could get processed. They have to go find other people to hear it. The different kinds of conflicts, personal and financial, and then just sort of overlaying both of those as perceived or potential conflicts of interest. Personal conflict of interest arises when a it's you or a family member or someone that you're closely associated with, or it's an organization that you participate in, or it's a cause that you feel very strongly about, where you essentially are in a position where you can't be objective about it. Those are the situations where you have a personal interest in the application. The other one, the financial interest, is a little more obvious. If you're an investor in a project, if you're the owner of the property, those are the easy ones. Where it gets a little more gray is if it's something that is going to affect your property values, or have some other kind of tangential effect on you and your finances. What you have to look at is whether the impact that you feel is going to be similar to that is felt by a significant portion of the community. So is it something that's only going to affect people within a quarter-mile radius? If that's the case, then maybe you do have a financial interest. But if it's a situation where everybody's taxes will go down if this is approved, your financial interest is really no different than everyone else's, so you may not have a conflict of interest arising out of, that kind of situation. One of the other parts of that is the perceived or potential conflict of interest where, you in your heart of hearts know that you can be objective about it. It doesn't really affect you. It's not really something that you care about deeply, but you want to step back and take a look and see what the perception is by members of the public. Is it an application by somebody that you used to be in business with, or someone that you used to be married to, or something like that? Or your employer, or an organization that you belong to. Sometimes it's better to err on the side of recusal when it's something that if it was going to be on the front page of the paper, it wouldn't look good, even if you can kind of explain away why it's not a conflict of interest. But if it's a situation that would undermine public confidence in the process, it may be a better option to recuse yourself and just sort of take the issue off the table. Yeah, this is kind of what we talked about on financial interest. Personal interest doesn't come up very often unless, I think it was one of the cases described a situation where the commission member and the applicant had been in business together. They've been friends for decades. They went on vacations together with their families and things like that. So the perception was that there was such a close relationship between the commission member and the applicant that, nobody really expected the commissioner to be objective about it.
Excuse me.
Yes.
I've been reading about the Supreme Court on that very issue. Mr. Thomas. Vacations and buying his parents' home and educating his children.
I think it doesn't look.
They should be setting the example, I think,
Yeah, you don't have to look too hard to find things that don't smell good, at all levels. One of the things that may come as a surprise to some people is that municipal employees are not eligible to serve on certain boards and commissions in the town that they live and work in. Board of Finance, Planning and Zoning, and Wetlands are some of them. If you're a small enough town that you're having a really hard time getting people to serve on boards and commissions, you can enact an ordinance that allows municipal employees to be on planning and zoning or wetlands. I think the theory, particularly on the Board of Finance, is kind of obvious that if you're setting the budget and you're in the budget, that there's a lot of potential for conflict of interest. It's a little less clear why planning and zoning and wetlands in particular would be on there. One of the other things to watch out for, and Mark sort of alluded to this in the context of contested hearings, is bias and predetermination. And bias is essentially where you have some kind of visceral feeling either for or against a particular person or position. Predetermination, which is similar to prejudgment, is when you've essentially made your mind up before the hearing starts that you're either going to approve or deny something, regardless of what evidence is provided. And in some situations, you can have both predisposition and bias. And, that's not good. Commission members and the chairman should try hard to make it so that the situation or the hearing and the proceedings are not hostile. As he noted, be careful what you say and how you say it, and how things could be interpreted, because they're, for example, when you're doing the transcript of the meeting, there is no sarcasm font that can, let a judge 2 years later know that you were kind of kidding. And again, if you allow particularly, prejudice of one form or another to inflame a public hearing, you're sort of inviting the opportunity for your decision to be overruled, and if it gets particularly bad enough, a civil rights claim that can lead to money damages. You got your hand up?
I was just wondering what happens to a commission member when prejudice and bias predetermined before their vote on a certain instance. What ramifications is there?
What the outcome would be is probably that the court would decide that the whole proceeding where the vote was tainted by that person's participation, and maybe the best case scenario would be having to hear the whole thing over again without that person participating. Alternatively, they could find that it sort of tipped the boat over for the whole commission, and if you voted to approve something, the court could order that it be denied. It's something that you want to clearly avoid. If you're in the middle of the proceeding and you can kind of see things going in a particular direction, it might be good for commissioners who are concerned about it to talk to either staff or the chairman about, can somebody talk to Joe? He's really sort of out of line here.
Could be accurate.
Maybe it's kind of obvious what his or her position on the application is, and maybe you should not come next week.
Or ever.
Right. Well, I was involved in, Mark did a 7-year sentence on his commission. I'm on year 33 on mine. And we had one application for a school-type facility. That was interesting, except that one of the commission members was asking all these bizarre questions about the landscaping. and was demanding that they go back and do entirely different landscaping that was more appropriate for what climate change would be like 50 years from now. And that we should basically have palm trees in the yard instead of the ones that were there. And to make a long story short, it turned out that he used to work for the applicant many years earlier, and on the day that he was fired, they had to clear the building. And the conclusion was that it took about a week for the chairman, the planner, and the town attorney to convince him that his questioning was so far out of line and was so obviously hostile to the applicant that he really should recuse himself, because they knew about the history at that point. And he was kicking and screaming, but finally did, write a 5-page single-spaced letter explaining why he didn't think he had a conflict of interest or any predisposition, but because he was being pressured to, he was going to recuse himself. So you can usually get people to the right position, but it's not always easy.
Thank you.
Again, the kinds of situations where an appearance of bias has particularly significant likelihood and also particularly significant consequences are when it's involving a protected class or something that enjoys constitutional protection, like churches, affordable housing applications, different kinds of group facilities. One of the towns in the middle of the state spent a lot of time and a lot of effort trying to drive a group home out of a neighborhood, and they ended up getting tagged with a $5 million judgment that was eventually reduced to $2 million that they had to bond for because they had created such a horrible atmosphere for these people just because of what it was. You don't want to be the kind of people that end up having that on your plate. Yes?
Backing up just a little bit. Okay, so we've got a commission member that feels they need to recuse themselves. They feel they're going to be. They feel like they could be objective, but they know the applicant is not going to be comfortable because of whatever previous history or a land abutter or whatever. Okay, so you come into the meeting, there's an agenda. Let's say that applicant is the third or fourth item on the list for the evening. Does the commission member wait until their turn comes up, and then the commission member recuses themselves and sits in the audience? They don't recuse themselves for the whole meeting, do they?
No, they don't need to. I mean, if the first three...
So build on that. After the applicant has gone through their thing, the commission has spoken, the commission member who has recused themselves, they are in the room, they are in the audience, am I correct?
Yeah.
Okay, they can stay in the room. May they also speak as a general audience member to ask questions of the applicant? Because now they're sitting out here as a non-commission member.
You can, if they're kind of simple questions, it's probably better if the commissioner can find someone else to ask the questions for them. It all comes down to whether their behavior cumulatively undermines the fundamental fairness of the proceeding. Whether they're so belligerently hostile during the course of their
So it might
recused
be
question.
a non-aggressive question. Can you tell me what kind of trees you're gonna plant in front of the store that's next door to me? You could ask something like that. I'm just trying to get a feel on how this is gonna play out. So anyway, so going on. So the applicant has, the commission member is now an audience member. The applicant has finished talking, okay, nobody's asking any questions. We're gonna move on to the next item, which is another applicant presenting something else. So the commission member, who's now an audience member, may now stand up and rejoin the panel.
Yeah.
Does anything need to be said when they rejoin? Do they have to be officially brought to life?
Yeah, revived. Well, the minutes will say, Commissioner so-and-so rejoined the meeting at this point.
Rejoin the meeting. Okay.
Presuming that when they left in the first place, Commissioner.
I'm just trying to get a process of how it may go.
Yeah.
Because questions have come up. This is not somewhere else. And so I was always just kind of curious about that.
Yeah, it's one of those things where you need to be kind of delicate about it because, you keep hopping from the front to the back.
Yeah.
The public perception can be, you
Well,
you were over there a minute ago and now you're up here.
Well, and that's why, in these small towns, a lot of these people all know each other.
Right.
It's going to be hard to find a commission if nobody knows anybody personally on the commission.
Right, and
There's
they're not all
always going to be overlap
cousins.
somewhere. So I think that's why I'm asking.
Yeah.
Yeah.
John?
Yes, to her point, I've experienced that where we had a commission and there could have been a conflict of interest. And what I did was I asked him to recuse himself. I stated the time and I asked him to leave the room because I felt it would be better this way he doesn't hear or see or could say anything from what I experienced. And then when the whole thing was done, we moved on to the next one. I had my staff member go out and say, okay, you can come back in. And then I said, okay, he's back in at such and such a time. Because that actually I found that it will eliminate anybody. Well, he was still in the room and he could have some influence or something. I'm just going by what I felt and what I looked up over.
Yeah, well, people can say he's sitting in the back flashing gang signs up at the other commission members.
But you can't deny someone the right to view that because it's open to the public. You can't deny someone it. You can't send them out of the room ahead of time.
There was one case where the court held that he needed to leave the room.
Was he being aggressive and everything? If they're not aggressive.
He was a case out of Marlboro. And back when Marlboro had an old town hall, the Marlboro meeting room used to be really, really small.
Okay.
All right, and what happened was a commissioner's wife filed a subdivision application. He got up from the table, he sat in the front row, 6 feet from his colleagues, staring at them while his wife's subdivision application was being heard.
Yeah.
And the judge said he should have left the room. Now, in the town where I live, the meeting room is the size of this one.
Yeah.
Right? If you were sitting in the back here, it's not the same thing. So it's a matter of common sense. If somebody's going to sit there, like Rich said, and glare at you, then they got to leave the room. And leaving the room is the safest thing because, as John said, then you avoid, signals or coughing or who knows what. Okay. But and yes, they can speak, and there was one exception from that Litchfield Historic District case. If the commission member has expertise, and they testify on that expertise on their own behalf, that they can't do. Long story. What happened? It was an historic district case where the member of the commission was an expert in historic preservation.
Okay.
He announced a conflict. He recused himself. He then testified as an expert. All right, and on appeal, the court said, how could his colleagues disregard his expert testimony, but he's one of them.
And so they should have gotten someone else.
Right.
Yeah. And that's what, and, you know, my question would be, if somebody becomes the public, if they're not aggressive or anything, they should be able to sit there, because they are, after all, whether they're on the commission, I would think, or the public, they have a right to observe what's happening in their town, I would think. Because if they didn't and they missed out, they don't know what's going on with that particular application, right?
Common sense.
Okay.
Yeah, I mean, and
So like you were saying, you know, you ask someone to leave the room if you anticipate violence or
That's the key.
negativity or an unfairness of some sort.
yeah, I mean, and
I'm not going to get a black or white answer, so I just want to get close. Like a really dark gray or a really dark gray, kind of really close.
yeah, I mean, it depends on the situation. I mean,
Okay.
if it's something where, you know, it's obvious that there's some kind of animosity or something that, you know, is going to rise to the level where it's
Okay.
depriving someone of a fair hearing,
Gotcha.
you
Okay.
know, it's better to go home than to sit in the back and glare and roll your eyes and clap and,
Okay.
you know, have everybody see that.
Yeah. All right, I think it answers my thoughts.
Okay, yes.
Carla Stratton's Planning and Zoning Chair in Plainfield, welcome to our town. My personal philosophy, being a 22-year member of Planning and Zoning, is when in doubt, get out. If your presence is going to jeopardize your board's decision, get out.
Yeah, and you kind of know, right?
And exactly. So when in doubt, get out. Don't jeopardize the rest of your board just because you want to know what's going on. You'll find out later. Read the minutes, watch the video, listen to the tape.
Yeah.
All right, I think that's a good answer. Yeah.
I mean, and one of the other things too is that when you're recusing yourself in a situation like that, it's probably best not to say why. You know, I'm recusing myself because the applicant is a lying sack of you-know-what. You know.
I have a question for Carla, but when does a chair or the town planner remove someone from their board?
You don't. So we are all elected officials. So it is our responsibility to determine our own recusal.
Okay.
So you can't force another member to recuse. It is their elected duty to understand when they can and when they cannot. Now, staff and attorneys can certainly suggest, persuade, but at the end of the day, it's up to each elected official. So have integrity, and when in doubt, get out.
Yeah, I mean, you don't have a vote to force someone to recuse themselves. I guess the good news is that, you know, without some kind of clear and convincing and compelling evidence, the court isn't going to overturn your decision. You know, there's a presumption that even though you are, you know, volunteers, that you're behaving properly. So, you know, it's kind of a high bar to overturn your actions. Predisposition is pretty straightforward. You know, you don't want to state ahead of time before the hearing opens what your position is on a particular matter. It can be difficult, if not impossible, for people who have to get elected to, you know, essentially campaign on the platform of, I don't know. You know, I have no opinion, but you want to kind of couch everything in the terms of, you know, this is generally my perception or my opinion on development, but, you know, we evaluate all the applications based on the merits and on the regulations, and so, you know, I'll have an open mind when they come in, even if it's not something, you know, that I necessarily am enthusiastic about. It's sort of a fine line.
These cases tend to be very fact specific. So that's why it's hard to give you these absolutely bright line rules. They do turn on the facts of each case.
Yeah, I mean, there was one, and, you know, the facts are kind of lengthy, but basically, there was a situation where one member of a commission ran for election on the platform of repealing a regulation that had just been adopted. And, you know, sent a mailer to every house in town to that effect prior to the election. And then he got elected, and at the first meeting, you know, made a motion to set a hearing to repeal the regulation. And someone said, well, you know, you have predisposition. You've already made up your mind on this application. And, you know, ultimately his response was, well, I have an open mind. You know, I'll listen to whatever anybody has to say at the hearing. You know, you may not necessarily believe it, but, you know, as long as you can say the words with a straight face, you probably will be okay. Yes?
Say I'm sitting on a board, and before the meeting, there's a group of people that, board members that are sitting there discussing the application in front of them, already saying that they're not approving it, and another board member saying, I am just going to do what the other board member does. Me as a person on that board, what do I do in that case if I overheard that being said?
I think my advice in that situation would be to say to them, you know, you may have that opinion now, but you really need to listen to everything that everybody says during the course of the application. You know, during the course of the public hearing. Otherwise, you know, you're predisposed and you made your mind up, and it's not a fair hearing.
Should I make an ethics complaint about that, or?
I think that probably depends a lot on what your ethics code says, and quite often that requires that there be some kind of favor or benefit to somebody who takes a position. You know, it's contrary to the duty that they have as a commission member, but you have to look at your particular ethics code to see whether it's a violation of that. All right, again, you know, the commission member has to decide for himself or herself whether there's enough of a conflict or a potential conflict or any other basis for recusal, and they should make that decision and announce it on their own. Again, what the court's remedies are in situations where there's either a conflict of interest or predisposition or bias is they could overturn the commission's decision, you know, particularly if, as you described, you know, 3 of the 5 people already had made their minds up ahead of time. You know, it wasn't fair. Your decision is overturned. You can send it back for a do-over without the people who have the conflict not participating. Potentially ordering approval. And, you know, the last thing is that if whatever transpires is proven to be a violation of fundamental due process and fairness in the process, and they can couch it as a civil rights violation, you know, there can be significant money damages that wouldn't be covered by insurance.
Question?
Yep.
When you say money damage is not covered by insurance, can you explain that, please? Is that
Personal
money damages against the individual or against all the commission members? I'm trying to understand that.
Well, it's tricky because, you know, It would be against the town and the commission, depending on what the people did. It could be against them individually, you know. And then there's the statutory obligation for a town to indemnify, you know, its employees and staff members, but that probably doesn't include, you know, willful violations of civil rights laws. So, you know, people may be on the hook for financial penalties on their own. I don't know whether your homeowner's insurance would cover it or not. Probably not. Well, the headline on this one somehow got deleted. I'll claim pilot error on that one. The subject is ex parte communication, and the short answer is, you know, to the extent possible, it should be avoided. You know, you live in a town, people know that you're on boards and commissions, you're standing, putting gas in your car, you're a captive audience. They come over and start ranting to you about, you know, I can't believe you're going to approve this application for the X, Y, and Z. You know, don't you realize that's going to be the most, you know, disgusting thing that has ever happened in this town? To the extent that you can, particularly if people are getting into specifics or information rather than just kind of a general rant, you know, and the hearing is still open, encourage them to come to the public hearing, come to the next hearing, and, you know, express your opinions there, or send in an email, send in a letter. You know, I really shouldn't be talking about this while we're out here, not at the public hearing. You know, it's difficult to unhear things. The other thing that's important about ex parte communication, kind of in the context of the general public, is there are different levels of significance. And if they're the 750th person to say, you know, this really doesn't fit with the character of the town, you know, you just kind of chalk that up to background noise. You know, it's the same thing that you've already heard from everybody else. But if they start talking about things that are either evidentiary or prejudicial, you know, like what Mark was talking about with the woman who was claiming to have seen the well. You know, if someone starts telling you about a factual thing related to the property or the application or the applicant, you know, that's new and different information that you think is relevant, you know, that's when you really need to find a way to get that information into the public record so that, you know, either the applicant or the opponents have an opportunity to respond to it if it's going to be something that is part of your decision making. That also, you know, just kind of capitalizes on why it's good to try to avoid ex parte communication and to shut it down, you know, as quickly as you can. You know, even if you are sort of out there in the public and, you know, there are people that you know who want to bend your ear about something, you know, it's like, no, we really shouldn't be talking about this because the hearing's still open. You know, come talk about it to the whole commission there. All right, Mark covered that in his presentation. It's dark out, so I won't cover it again. Again, the kinds of ex parte communication that are particularly problematic are ones that are evidentiary or prejudicial, where in order to be fair to either the applicant or the opponents, you know, they would want to have the opportunity to either explain or respond to that information. conflicts of interest, this is a kind of a cut out of an early decision that essentially says that, there's a recognition that in local government, you're bound to have, relationships, with people that may affect that may tie you to an application or to an applicant. And it essentially says that it has to be something significant. It can't be remote or nebulous, that those kinds of interests aren't a conflict of interest. Similarly, on predisposition, this quote from the Supreme Court says essentially that they don't expect members of land use commissions to have no opinion about the development of their community. In fact, they would find it odd if you didn't have, opinions about the development of your community. It's just, you can't have made your mind up before the hearing begins that you're either going to approve or deny something regardless of what you hear. Yeah.
One thing the internet, social media, this is becoming a huge problem. Where commission members put something on Facebook.
Oh, yeah.
I'll never vote for that. I'm against that. Or I'm totally in favor. It doesn't matter, right? That information is out there, folks. And the other, as far as ex-parte communication, cell phones. I was at a hearing, I'll tell you where it was, the English speaker, where the meeting was a virtual meeting, and people were texting commission members on their phones, ask them about this. Did you see, Commissioner, I'd like to know about, so they're reading from their phone, all right? You gotta keep people from doing this stuff.
Yeah, the stuff that I skittered over there was just some kind of lengthy hypotheticals that are part of the program at the Land Use Academy. And, we can get you all the full document that includes the questions and the answers, because, as we talked about tonight, so many of these things are fact-driven, and my portion in particular has a lot of which of these situations is a conflict of interest, which of them isn't, and so forth. And they come from real cases, and they basically show that the answers are all over the lot and depend heavily on the facts of the situation. One thing that Mark had talked about during his presentation that I had forgotten about until just now was talking about reconsideration. In all of the meetings that I've ever been to, I only saw reconsideration come up once, and what essentially led the commission to reconsider their decision was it became obvious that one of the it was a commission with 9 members, but it required 5 votes to approve anything. And there were only 5 members present, so everybody had to vote in favor of things, for something to pass. And there was a vote on a particular application that was 4-1, so it failed. And the one member who voted against it, as things developed, it became obvious that he didn't hear what the motion was, and he thought we were voting on something else. So, ultimately, we explained to him really loudly, what it was that we had, in fact, voted on. And he was like, oh yeah, I'm in favor of that. And it's like, well, but you voted no. so we needed to basically make a move to reconsider so that he could change to yes, and as a result, there's a Dunkin' Donuts on a certain property in town, where there wouldn't have been because he didn't know what we were voting on. John?
I got a couple of questions, because one, maybe the both of you might have to be able to answer it. And I already had this situation come up, and I did a little homework, which I like to do, but you gentlemen are the experts, and it says, I asked, and the question was asked, based on Connecticut state statutes and regulations, there is no state statute that prohibits a commissioner or presiding officer from asking questions at a public hearing for an application. And the other part of that is that can a planning and zoning commission can and often should ask questions of the applicant, their representative or town staff during a public application hearing. And we kind of almost put the squash. We felt it wasn't appropriate that commissioners could ask this applicant certain questions, and it could have changed how things got voted. But is there a real statute or no statute that says that commissioners, and then another part says that the state again says that a commissioner cannot ask questions at a hearing for an application. So it gets, it's a little confusing.
Yeah, I guess the short answer is there is no statute that says whether you can or can't ask questions. I think the second short answer is obviously you can ask questions. Where it gets complicated is what are the questions? Are they related to your regulations? Are they relevant to your regulations? Are they questions that could lead to discussions that go in an improper direction? Well, what kind of Muslim ceremonies do you plan to have here? What kind of people are going to live in this affordable housing? Those sorts of things, I think, yeah, they are in fact questions, but they're not necessarily relevant to the application. They're not necessarily relevant to the regulations, and all they will do is get answers that may lead someone to make a decision for the wrong reason. So if you're asking questions that are designed to determine compliance with the regulatory requirements or public health and safety in general, ask away. But if they are questions that are related to things that are not legitimate basis for you to make a decision, it's probably better not to go there, because the question I would ask the person asking the question is, what are you going to do if you don't like the answer? What are you going to do if the answer is X as opposed to Y? Because that's, probably an inappropriate reason to approve or deny something. So you need to focus on what the question is, how it relates to your jurisdiction, and not things that are outside of your jurisdiction.
In other words, as long as the question that's being asked or whatever is within the application that was applied for.
The application and the regulations, and regulatory criteria.
Yes, I'm sorry.
Yeah, our firm had a case involving the Chabad House in Lincoln Borough, Michigan, where the wrong questions were being asked, and the original verdict from the federal court was $7 million. it got written down to only about $800,000 that the borough had to pay. Another client sued the town of Fairfield for $3.4 million, and they settled for a little under $1 million. The hearing that I had on in this area were involving the Islamic cemetery. Somebody shouted out, how are you going to bury them? It's none of your business. All right? It's a cemetery. How they bury them is their business and not a zoning issue. Someone else asked, is this going to be a terrorist training camp? Obviously not. You know, those kinds of questions will get you, if not, forget being overturned on appeal. We're talking civil rights actions for millions. Those kinds of questions you cannot, that is the atmosphere of hostility. That is, and the same thing like with applause. You know, people feel intimidated about saying something. If the other side's getting applauded and you're getting booed, you're less likely to, most people don't want to be booed. I mean, they sit so they're quiet, but you've now chilled people's right of free speech.
How fast should a chair or commission handle those inappropriate questions when they're coming from the public?
Instantly. Stop it immediately. That is out of order. We are not going to tolerate those kinds of questions. Yes?
As a staff person, can the staff person say out of order, or do they?
If no one else does, yes. I mean, it's best if your chair does it. It's best if you're a town. As I said, if you've got one of those hot, I mean, this Islamic cemetery, they had town attorney there, they had me there, right? But you cannot allow those kinds of questions. You can't allow those kinds of things to be said. Because it will, like I said, we're not just talking losing an appeal, we're talking money. So somebody has to shut that down right away.
Ask another question. How about, and there was had a situation of this, a prior applicant, someone was coming in, well, they're being sued here in this town, they're being sued here in this city, they're doing this. Not a good person for our community.
First of all, as all of you know, the permits run with the land. So, your local saint might apply for a permit and you grant it and he sells it to, the derelict son-in-law or something, right? So it's never, you should never consider the personality of the applicant. It's the application and compliance with the regulatory criteria. One thing we'll mention before we leave, two sources of information you should know about, if you don't already. One of them is this nice book, okay? The Connecticut Bar Association sells this. It's called Connecticut Land Use Law, Municipal Land Use Agencies, Boards, and Commissions. I forget what they're selling it for right now, but it's the cost of printing and mailing. All the authors of this donate their material. They don't make anything on it. So it's actually sold for low cost. The other book you should know about is by our partner Mike Ziska. I think a lot of you are familiar with. Mike wrote, years ago, he wrote a book called What's Legally Required. He just updated that last year. And that is for sale by the Land Use Academy, part of CLEAR, Connecticut Land Use Education and Research, which is part of UConn. Mike again donated all the work to write that book, update it, and all the proceeds go to CLEAR to use toward their educational programs for people like you. So those are two good sources of information there's some repetition in this one, but there's a lot of material in here, and Mike's book is just great because it's easy to read. Pretty much everything you ever wanted to know about land use law, we're free to ask is in there. Other questions, other thoughts?
Thank you.
Well, thank you for coming. Thank you.